next week we will meet you in class in person. Okay. Let's say, so how many people are here? Okay. Almost everyone, huh? Did you receive the first slide that I sent in your Blackboard? Everyone, I already sent the first slide of our first lessons. I upload in Blackboard. Can you get? Oh, cảm ơn nha. Okay, sorry about it. Once again, did you receive my slide on Blackboard? So I'm gonna show you.
Yes, I do.
Okay, good, very good. So I think that will help you something, and I will try to upload some more things in your Blackboard. Okay. Now I think we should start. Did you hear some noise somewhere, or you feel the sound is okay? Okay.
It's a bit noisy.
A bit noisy because actually I'm not in Ho Chi Minh City. I'm leaving for my business trip in Mekong Delta. So I currently in Rạch Giá City. So any of you have been, any of you are from Kiên Giang or Rạch Giá City in this class? So if you have chance that you can go there, this one is a very nice city. In the hotel, so I currently in the hotel, so in the near hotel there are the construction site, so it make a big noise, but sorry about that. Now I think we should start our lesson. So first I want to share our slide. Okay. Right, we are in the second class, second sessions, second subjects. This is the legal form of business and relations. So we study the first forms of business or enterprise, that is a private enterprise. And then we finished the enterprise, and then we went to the second type of enterprise, that is a partnership. So let's just summarize something about a partnership. A partnership is a forms of enterprise in our country. These have legal entity status, that is unlike private enterprise. A partnership will have at least two members. They act as the co-owners of the partnership, and the partnership will conduct business under a common name. The partnership works based on the personal identities of the partners, and the partners can be general partners and limited liability partners. Limited general partner or unlimited liability partners, they are the co-owners, they are co-managers, and they will be in charge of business activities of the partnership. And unlimited liability partners will be liable for the debt and the financial obligations of the partnership. In the case the access of the partnership is not sufficient to cover the debt and financial obligations. Unlike unlimited liability partners, limited liability partners, they are the partners that contribute contribute capital to the partnership. The important things that we have to remember, that is the question of how access of a partnership is formed. And the access of the partnership will be capital contribution from the partners, including the contribution of general partners and the contribution of limited liability partners. The access of the partnership will be created by the activity acting under the names of the partnership, by the contributions from other single general partners acting on behalf of the partnership, and also the access of the partnership also created from the activities of the partnership, although they created personally. And then we also discuss the advantage and disadvantage of the partnership. And we also have some restrictions to the rights and obligations of general partners or unlimited partners will be decided by the law on enterprises. And the current law is the Enterprise Act 2020. So please let me know if you cannot hear the sounds clearly, or let me know if you missed something. Okay, now can you read here? This is the question of what kind of rights of the general partners. So the first right is the rights to attend a meeting, and all general partners have the right to attend the meetings of the partnership, and they have the right to discuss and decide the matters of the company, the partnership by vote. Everyone, now remember here, every general partners have one vote, and basically the law on enterprise providers, a general partner will have one vote. So when I say each general partner has one vote, that means the vote will be equal. In some specific case, if the partnership charters or the company charters provide in the other ways, that means the general partner may have more than one vote. In principle, every general partners have one vote. Can you notice anything special here? Can you see any special? Can you see any special things from these provisions? So the law say each general partners will have, right? Each general partners will have one vote. Can you see anything special? The law say each general partner has one vote. That means every general partner will have equal right, and they have the same right to decide everything according to decide every issues of the company. Then we say every general partner has one vote. That means it will not base on the contribution. So let's imagine we have a partnership with 5 members. So actually we have 5 general partners. So all 5 general partners are equal. So when, for example, we decide issues in the partnership, and everyone will have one vote. So the interested things in that means, for example, the first general partner contribute half of the capital, The second general partner contribute 20%, and the rest of three general partners contribute 3%, 30%. So that means there is imbalance in terms of the capital contributions. But the thing is that when they vote, everyone have the same vote. So it doesn't mean that the more capital contribution you have and the more vote you have. It's not that one. So it doesn't matter. It doesn't matter how much do you contribute the capital to the partnership. But when we vote, that means when we decide anything in the partnership, we will have the same vote. All right. So that is the things. The general partners will have the right to conduct business activities in the name of the company. So everyone have the same right to negotiate and to sign contract or agreement with the other parties, and they have the obligations to consider anything that is provide the most favorable for the company. So, for example, the partnership have 5 general partners. Every one of them can independently sign and negotiate contract with any partners, and the contract will be signed under the name of the partnership, or even they negotiate and sign the contract under the name, not under the name of the partnership. The money that earned from that contract will also belong to the partnership, and we also remember. The general partner have the rights to use the shares and access of the company. For example, they can use the property, they can use the card of the companies and something like that. And if they advance money, that means they use their money for conducting the business under the name of the company, so they can ask the partnerships to refund the money. Now, for example, like I have the business trip and the expenses for the business trip, I can pay by myself. And after return to the company, and I can ask the partnerships to repay.
Teacher, you mute your microphone. Your microphone email.
Okay, can you see now? Okay, right. So I think that you can hear me now. Okay, I'm talking about that the right of the general partner when they can use the properties of the partnership, and they can also, after the business is finished, they can claim the compensation from the company. Right? They can also request the companies to provide information about the business. They can check documents of the so. For example, they concern that there are some mistakes or they have some problem, or they just want to check if the documents of the company are correct. Now we have to remember that partners have the right, but also it becomes the obligation of the general partners because they have to act on behalf of the company. So once again, I stressed on this that the partnership, they can be individual person, but when they do business, they have to do for the best benefit of the partnership, and they have to do whatever they think that can bring the most favorable for the company, not for themselves. And the money that they can earn from the business activity will become the access of the company, as we already mentioned. Now, in the case the company make profit, basic rights of the general partner is that they will be distributed with profit. So it happens on every year. So when the partnership make profits, and after that they will be distributed after fulfilling any kind of financial obligation. So the remaining profit will be distributed. So the question is how to distribute the profit. The profit will be distributed corresponding to the amount of the contribution. So for example, like in the partnership, I contribute 30% out of total contribution. So that means when imagine that the partnership make 1 billion profit after deducting any kind of debt and financial obligations, the remaining profit is 1 billion. So I contribute 30%. So that means I will receive 300 million for the profit distribution. Okay. To a bankruptcy. So that means they cannot pay, but they cannot pay the due debt, so they have to be bankrupt. After the access of the company will be used to pay for the debt, the remaining access will be distributed to the general bankers according to the proportions of their contributions. However, the company can do another way. That means, for example, they can provide another ratio that is depending on particular partnership. When the general partners will be declared, when a general partner debt, for example, like someone died or someone has been declared by the court to be missing, the heir can enjoy the share of the company corresponding to the contribution of the general partners. Okay, now let me ask you one question. Okay, regarding the case where the general partner died. Now, for example, like in the first case, there are 5 general partners in the partnership, and the contributions of partner A is about 30%. So he contributes 30% of the capital contribution. Imagine that he passed away, and then his or her heir, that means the person who can eligible to receive the property, that person. Okay, so how much does he or she will receive if the company distribute of profits? Okay, once again. Okay, right. The partnership have 5 partners, and partners A contribute 30%. And imagine he died. And in these years, the partnership make 1 billion profit. The question is, how much could his or her heir may receive? So, do you think the question clear to you? It's simple, right? We have profit 1 billion. The partners die and he contributed 30% and he has his or her heir. And the question is, the heir will receive how many percent of the profits that the heir will will receive?
Still 30%.
Yes, till 30%. Yeah. Now the second question. Okay, we have the second question. Now imagine, okay, the total capital of the partnership is say 10 billion. Okay, and his contributions made up 30%. Okay, now the company got the debt and they could not pay by the access of the partnership. Say the partnership got in debt and the total financial obligation they have to pay is 20 million. Okay, 20 million. And the property of the partnership is 10 billion. So that means there are 10 billion remains to be paid. The question is that this general partner passed away, and the question, there are two sub questions. The first sub question is that whether his or her heir still have to be responsible for paying the remaining money. That is the first sub question. The second sub question is that if his heir has to pay for the rest of 10 billion, okay, how much his or her heir has to pay? So you see that the question is clear, right? So the debt 20, the access of the partnership is 10. So the remaining money they have to pay is another 10. And he died. And his heir, there are two questions, whether his or her heir has to be paid for pay corresponding to the contribution for the debt. And the second question, if they have to pay, how much they have to pay. Do you think clear? For the first questions, do you think that the heir have to be liable for paying the remaining debt? Okay, in this, yeah, the answer is yes. Okay, so it's very interesting. So when you can inherit the right, it also means you have to inherit the obligation. That is the first thing. So the heir still has to pay. So the heir has to be together with the other four partners to cover the remaining debt. And the second question is that how many percent they have to contribute. And the answer is
30%.
30%, yeah. So corresponding to the contribution. But the problem is that you see the problem, and it is also one of the disadvantage of this form of partnership. That means they have to be very, they have to work very close and they have to understand each other. Because can you see that I contribute 30%, okay, but I still have one vote. You have contribute 10%, but you still have one vote. It's unequal, right? So somebody, for example, may say, "Hey, this is not fair because we contribute different, but we have to have equal right for the vote of anything." Okay. Now, the next thing is that we have to look at the obligation of the general partners. In the law, it says the general partners have to work, okay, for the best lawful interests of the company and all members. So that they can do whatever they want as long as it brings lawful interest for the company. All right. So that is the obligation. The general partners has to share the task of manage. And they also sharing in terms of conducting business activities of the company. It will be provided by the law on enterprise, by the company charters, by the resolution of the partners council. So we will talk about the partner council later. The other obligation of the general partners is that they have to be responsible for the compensations if he or she did not provide. So, for example, he may did something wrong, and he did something when he did not follow the rules, causing the damage. Now, I'm gonna give you another example. Now, so I am a general partner. Okay, I'm general partner, and imagine, right? Imagine that I I have the information about a project, and then I decide, all right, to invest the partnership capital in this project. Unfortunately, the project failed, and this investment caused a big loss for the company. So it comes with a question that whether I have to compensate for the partnership for the damage caused by myself. Okay, I make the loss, but when I make the loss, I end up general partner. So it comes with a problem is that whether I have to pay back to the company. So in this case, we have to define it into two different situations. The first situation is when I did not follow the advice, that when I did not follow the rule, I did it for myself. And I did not, I make mistakes. It comes from my knowledge, and I violate the rule because, for example, the company sets the rule that for the investment, for some kind of investment, every partner has to discuss with the other general partner. But I did not discuss with our college, and I did it for myself. And the loss caused completely by my mistake. So in this case, I may have to compensate for the company. But the second situation is like when I follow all the instructions, when I follow all the rules. But the project failed for objective reasons. It could not come from my fault. So in this case, I may not compensate to the company. All right. So we have to divide it into this. And the other rule is that the general partner, could not use access of the property for personal benefit. Now, for example, let's think about it. Now, say our general partners, our partnership have a result in somewhere like football, for example. You know, our company runs a resort in football. So I am a general partner, and then I bring my wife and my family to the resort and stay and do not pay. I didn't pay anything. So in this case, I can be say it can be say I used the property of the company for the personal benefits. Of course, in some case, it is due to the policy of the partnership, that is, members can use part of access of the company, but uh, in order to avoid so the obligation of the general partner is not to use the access of the company for the benefits of the partnership, the partners, or even to benefit of another individual. Now, for example, our partnership have a project. So this project is still in planning, and I told my wife, who is not a general partner, my wife work for another company, and I told my wife, hey, our company has excellent project, and here is information. Can you contribute to this, or can you invest or something? Can you buy property, or can you buy share for this? In this case, it is not acceptable because it will bring benefit for another organization or individual. Another example is like I work for the partnership and I have the list of our clients. So the list of our clients is gonna be secret, for example. And according to the law, I cannot disclose this information to anyone else. But I went home and I told my wife, who works for another company, and I say, here, I'm gonna give you this client list. And my wife make use of this client list for her benefit. So in this case, it will not be acceptable. That is the other obligations. All right. The obligations, sorry, this is not right, obligations. The other obligation is jointly liable. Now, jointly liable, that means they have to be liable together with other partners in the company. Okay? So, to be jointly liable, that means to be liable together with all the general partners. To discharge, that means you have to pay the outstanding debt of the company in the case access of the company is insufficient. It's insufficient means the remaining access of the partnership cannot pay. So the total debt will have to be covered by the general partners. So I would like to ask another question. So in this case, whether limited liability partner will be liable too. Okay, the question is that when the company have the debt and the remaining access and the access of the company cannot pay sufficiently, and general partner will be jointly liable to pay for the debt. In the same question, another question, okay, whether limited liability partner will also jointly liable? Yes or no? Remember that we have two types of partners, yeah? General partners and limited liability partners. General partner must be liable together with other general partners. But the question is whether limited liability partner will be liable together with other general partner too? Yes or no?
Can I answer this?
Yes, you are handling, right?
Yes.
Okay, excellent. I'm waiting for your answer now.
I think yes, the limited liability partner is liable too, but to the extent he or she contribute into the
Yeah,
partnership, not
yeah,
to
yeah.
not
Correct.
unlimited liability like the general partner.
But you correct a little bit. That means they will liable to the extent of their contribution, and their contribution already become the access of the company. Okay. Now, for example, I am a limited liability partner. Okay. I contribute 500 million. So 500 million after I joined the partnership, these 500 million will become the property, the access of the company. So after the company have the debt, I will not have any liable because my liability is already transferred to the company when I contribute the capital. So I do not have to pay extra money from my personal profit. That is the point. Okay. So you also asked me like, what is the benefit? What is the benefit of a limited liability partner? What is the benefit?
I think the biggest benefit is that he or she will not have to pay extra money when the company is in debt, like
Yes.
you have explained to us. That's the biggest advantage.
And then you can still receive profit. Right?
Yeah, still receive profit to the
But
extent
when the company got a problem, I say, oh, sorry, I do not have jointly with you guys. Okay. So the general partner, please, all right, handle with this case for yourself because I have no extra money to pay. I have no obligation to pay this. So that is the first obligation. The partners, general partners also have to pay losses. And of course, in this case, limited liability company, limited liability partners also has to be losses also because when the company lost, everyone lost. But when the company make profit, everyone have profit, the dividend. But when the company pay losses, so everyone has to pay losses. So the obligation, the common obligations of the general partners. Now, moving on to the other ones, they have to support, they have to submit the report to the company, depending on the policies of the company and other obligations. Now, so also we have to little bit something about this. The limited liability partners will be something like an investment. So let's just say the law provides and give our investor a number of choices. For example, if I have 500 million, so I'm thinking about making money from my 500 million. I can send it, I can deposit it to the bank and earn interest. I can buy share from the shareholding company, but I can also invest it in a partnership and also receive the profit. So it's dependent on this. So limited liability is not compulsory. Whether a partnership have the limited liability partners depending on the policy of the company, whether the company wants to have limited liability or not. They will contribute capital, and they sometimes the limited liability partners can become members of the partnership by inheritance or by donations, or when they can buy share. For example, another limited liability partner is who already the members of the partnership. He doesn't want to go with this partnership, and he can transfer the shares to me. So in my case, it had no problem. Okay, in my case, it's gonna have no problem. But when you look at the restrictions, okay, the restriction to the general partners, you will see the thing is that the general partners cannot transfer a whole or cannot transfer a part of the capital contribution to anyone else without the agreement of the remaining general partner. I remember that I explained to you guys that it is because the partnership is a special form when general partner can work together. So the replacement from one general partner by a new general partner must be by the remaining general partners. All right. But a limited liability partner is nothing much to say. Again, it can transfer easily because he or she will not be liable for anything this. Okay, now moving on to the organization and management. So this form of partnership, once again, this form of partnership based particularly on friendship and teamwork. So therefore, the organization and management will be very simple. Now you can look at the structure here. It's divided into unlimited liability partners and limited liability partners. Limited liability partners is in the red and the general partner is in the blue. And here it say unlimited liability partners or general partners, they are agents of the partnership and has fiduciary. Fiduciary, that means the duty of making trust. So general partner have to trust your teammate, and every teammate has to trust in a single in a particular general partner. That is called fiduciary duty. I trust you and you trust me. Okay? So we work based on teamwork and based on trust. Okay? Because you can do whatever you want. I can do whatever I want as long as it's under the common name. As long as it brings the benefit for the partnership. So it has to be fiduciary duty. And general partners will manage the partnership. In the other hand, the limited liability partner have no involvement in management. So they cannot have anything in terms of the management of the partnership. So the structure is like this. All partners, all right, form a partners council. A partners council or the council of partners made of all general partners. And the council will be headed by another general partner. So always remember the partners council is formed by all general partners. So they form the council. And one of the general partners will be elected randomly, right? By turn. They take turn like a circle. Everyone will serve as the chairman of the partners council once, because everyone has the same right. So they will be elected. For example, this term I will be the chairman. Next time you will be the chairman. The chairman of the partners council also the director or general director. So basically, as we just said, a general partner has one vote. So the vote will be counted by head, not counted by share. So it cannot mean, it doesn't mean that your contribution is big or less, or even you may not contribute anything, right? You also have to have one vote. Now, concerning the limited liability partners, they can have some vote. So that means I say again, like limited liability partner cannot involve in the management, but they can be invited and they can have some voting right for the matters that relate to their right. Okay, that relate to their right. So, for example, like the partnership decide to a specific issue relating to the right of limited liability. So they have to attend the meeting and they have to participate in votes whether they accept it, right? So we have to say that the Partners Council is the organization that runs the partnership, but they will not uh, have the participants of the limited liability partners unless unless something that relate to the unless relate to their partners. Okay. Now, the management of the partnership is also simple, right? The all general partners will be the managers. They are co-managers. They act as the co-managers. They are representative at law of the partnership, and they share the task of management. They share the task of management and they share the task of control the partnership. So they have to have like arrangement of allocation of the task. So you do this, I do that, the other guy do that. So we have the agreement. So no one is the boss. We are the boss. Okay, but you do this, you do this. It's something like in a football team, right? So everyone has to play for the benefit of the club. But in the field, like you are the goalkeeper, I am the defender, you are the forwarders. Okay, and then you can take turn or you can change this. So that's finish the partnership. Now, moving on to the third form of enterprise according to Vietnamese law. That is called limited liability company. Okay? Limited liability company is something like this. Now, for the definitions, limited liability company or LLC, okay, is a business form with legal entity status. So similar to partnership, limited liability have legal entity status. And limited liability company share the characteristics of a shareholding company. Here I say SC, that means shareholding company. They also have to. They also share something similar with the partnership. They have close relationship among the members. So that is the similarity with the partnership. So remember, the foundation for the partnership is based, right? The foundation of the partnership based on friendship. That means a close relationship. Limited liability company is also the same. They have close relationships amongst the members. Okay, now unlike partnership, each member of limited liability company will have limited liability. So they will not have to pay, I mean, like extra money for the debt of the company. The limited liability company is basically small, so it is a small size enterprise. So according to our law, maximum members of the limited liability company is 50, and the minimum is 1. Okay. In Vietnam, that we have two types of LLC. First one is a two members limited liability company, and the second one is two or more members limited liability company. Another problem for limited liability, that is they cannot issue of security. So they cannot attract the capital contribution like shareholding company. Now begin with two or more members. This one I think is quite popular in our economy. So two or more members limited liability company or multi-member limited liability company is enterprise that have from 2 to 50 members, that are organization individuals. So let's take a look. Okay, and take a look at the characteristics. Limited liability company with two or more members is a form of limited liability company. It has legal entity status. So far we see that limited liability and partnership have the same thing in common. That is, they have legal entity status. And these characteristics make it different from a private enterprise. That is the first characteristics. And in order to be legal entities, the entity has to qualify 4 conditions here. Now the second characteristics of a limited liability is that the members. So look at this in the first corner here. Limited liability company can have the member as organization or individual. Now, can you point out, right? Can you point out here, right here, the difference, the distinction, right? The difference between limited liability of 2 or more members and a partnership in terms of the members. Can you point out the difference between a limited liability company and a partnership in terms of the members? Can you point out it? So you can see it here, okay? You can see it here. For the partnership, right? Members of the partnership, including member of the partnership, is individual. They cannot organization. But the members of a limited liability can be organizations or individuals. For example, my company is a limited liability company, and then my company can use the property of the company to establish another liability company. So in this case, my company is a member of another limited liability company. That is because the law allows organizations to become the members of a limited liability company. Private enterprise, the members is only individual. Partnership, general partner can only be individuals. But the limited liability company, the member can be individuals, or the member can be organizations. They are based on close relations that they know each other. And for the multiple members, they have at least 2 members, and the maximum is 50. So if the member can exist 50, so they have to be converted into this sharing company, or they have to be divided. Regarding the next one is a limited liability So the company is liable for the debt and the obligations by the company property. And the company property is different from the property of the members. So when the member want to establish the limited liability, they have to contribute the capital. So when they contribute the capital, their contribution will become the property of the company. All right. Now, I would like to ask you a question. Okay, I've just said, I've just said that when I went to organization to become the members of the limited liability company, they have to transfer the contributions from the personal capital, and after becoming the members, it becomes the property of the company. So what is the benefit, right? What is the biggest benefit to become the members of the limited liability company? What is the benefit? Because when I become a member of it, my property will be transferred to the company, and it will not be my personal property anymore. Now, for example, like there are 3% will form a limited liability company. So the first one contribute 1 billion, the second one contribute 2 billion, the other one contribute 2 billion. Totally, there are 5 billion. Now, imagine that when they decide to become the members, they have to transfer. So after the company is formed, the company have 5 billion, and 5 billion is the company property. So what is the benefit? Someone say, hey, I become a member of the limited company, so I lose my property. No.
Can I answer this?
Yes, please.
Yeah, I think that the biggest advantage is there is a separation between personal property and company's assets. So when the company is in debt, the members will not have the liability to pay any more than his or her contribution.
Yes.
It's kind of similar to the limited liability partner in the partnership. Yeah.
Beautiful. Right. So the members, another benefit, I just added something that benefit, okay, I will, when I contribute capital to the committee, I will not lose my property, I still have the members, and every year I will receive the profits, and I can, I can withdraw my money. Now, for example, I contribute 1 billion. After becoming the members of this company, I don't like to do business anymore. And I ask the company, can I withdraw my 1 billion? So in this case, the company will have to refund 1 billion to me, and then they reduce the capital. Okay, they cannot issue share, so they cannot. So that is the difference between a limited liability company and a shareholding company. Now, can you take a look at the question of change of membership and capital contribution? This is so a little bit complicated and limited. Now, can you spend a few seconds to read this? Okay. Because I'm saying that the change of membership and the capital contribution is complicated and limited. Why? So you will see that the transfer is not free. It cannot easily to transfer. Now, for example, I contribute 1 billion in my company. And of course, I can withdraw my 1 billion, but I can also transfer to another one. Okay? The thing is that if I want to transfer, for example, I want to transfer to my wife, who is not the members of the partners, a limited liability company. This will have to go through a process because I cannot offer to transfer the contribution right away. I have to offer to my existing member. So imagine that my limited liability company have 3 members, A, B, C. Okay, A want to transfer the contribution to someone else, for example, to D. D is not the existing members of the limited liability company. So before they can transfer to D, A have to make the offer to B or C. So that means A will ask B or C that whether they are interested in receiving the transfer. So if B or C say, okay, we don't want it, okay, or we cannot afford it, or we don't want it, we are not interested in getting your transfer, and after that, A can transfer to D. So that means the 2 steps. The first step, it has to be made internally, right? They have to make the transfer internally. That means they have to offer to the rest of the members. In the case of receiving the gifts or the share as the payment, now, for example, the contribution can be used as a payment. For example, A, B, and C is a limited company. Now, A has a debt of 1 billion. So instead of pay 1 billion to the creditor, A can use 1 billion. A can use 1 billion in the contribution and transfer in the form of a payment. So in this case, the creditor may become the new members of the LLC, right? Now, for example, like they have to pay for the bank 1 billion. Imagine that they have no money, so they transfer the contribution from the bank, all right, or from the bank to the bank. After they met the offer to B and C, because B and C doesn't accept it, they do not accept it, they don't want it, so they have to pay for the bank by 1 billion. So the bank now basically will become the new members of the LLC. All right, but in this case they have to approve if they want to use the contributions to be a payment, that they have to be approved by the members council. For the case of inheritance, for example, in the case of inheritance, the heir will automatically receive, right? The heir will automatically receive the inheritance, and they may become the members. All right. Now you look at it how to become the members. So first way is to become the founding members. The second one is buying a share. That means they obtain a new contribution. For example, there is ABC. They are forming an LLC. Now, for example, they want to get it open. So they attract B, D, E, F or something. The new member will contribute the capital, make the total capital of the company is bigger. all the existing members can increase the share. So new members can go and we become the new members. So buying the share, that means buy the share of the company members or contribute additional share, that means attending a new member. Often the share of the debt payments, for example, in the case that I give an example, like for example, A have 1 billion debt with the Bank. So A get the approval from the member council to use their contribution to pay for the debt for the Bank. And the Bank will become the members of the LLC. And the other one is receive gift or inherit from the share of the members. And become terminating the members like first one is someone die or someone declare debt or the company stop or the share is wholly transferred or only other cases specified in the company charter like use the capital like payment. Now we have to look at the right obligation of the company members. The rights of the company members here in the LLC will not distinguish between the partners or general members or limited members. All of them are limited members. Okay. So according to the Article 49 of the Law on Enterprise 2020, there are some basics right. So for the first right, it's similar to the partnership, but this point is totally different from the partnership. So remember, general partners will have one vote, regardless the capital contribution. But you can see it here, right? You can see it here, the members of an LLC, okay, will have different votes depending on how much they contribute to the company. That means you contribute more and you have more vote than someone who contribute less. So the vote is not equal, right? The vote will totally not equal, like in the partnership. In a partnership, I say it again, in a partnership, regardless how much you contribute, how many percent you contribute in the company, but you will have one vote, but in the limited liability companies, the vote depends on how much you contribute to the company. So the more you contribute, the more power you will have. Okay, we say that again, the more money you contribute into the company, the more power you will have. So if you contribute a lot, for example, if you contribute more than a half, or even you contribute 2/3 of the contributions, you will be the boss of the company. Okay, you will be the boss of the company. You do not need to contribute total capital. Okay, the perfect is like you control 99.9% of the contribution, and the other contribute 0.01. It's okay, but it's not necessary. You can also contribute around 75% of the capital contribution. The company is yours, right? That is the thing. The two other right is similar to the members of the partnership. That is, they have to be distributed with profit. So in this case, it is similar to a partnership. That means the profit, the vote in the partnership, the vote is the same, but the profit distribution depending on the capital contribution. So that means the more you contribute, the more money you will be shared, you will be distributed. So if you contribute 30% of the capital contribution, so you have 30% of vote, and then also the profit will be divided to you 30%. You also have the right to distribute the remaining access when the company went go bankruptcy. This is similar to the partnership. You have the right to make additional capital contribution. So here is given priority. Okay, and then priorities means you be the first. Now, for example, in the LLC we have A, B, and C. Okay, totally three members contribute 10 million, 10 billion, and after that they decided to increase double the capital contribution. And then they have the policy that the current members will have the choice. So if they have money, they will put extra money. If they cannot have money, so they can offer, they can invite someone. That is given priority to making additional capital contribution. Additional capital contribution, so an extra contribution after the company starts. They can be disposed the share for the donations, for example. So, for example, I contribute 10 billion, and now I say, can I get 1 billion for donations? It can be, it is okay, right? So in this case, the capital, the contribution of this person will be reduced. So you contribute 10 billion, but now you get 1 billion for donation. So totally you will have 9 billion. And the total capital contribution of the LC will be reduced. Now the members of the partnership will act on behalf of the company to take civil legal proceedings against the chairman. So that means if you are a member, you can take legal actions against, you can take legal actions against the chairman, or you can act any actions against any other members of the company. If you believe that they make mistakes, or if they believe that they violate the law. So you can sue the manager. So they can repurchase the member states. Okay, they can ask the company to repurchase. What is repurchase? So it can happen. It can happen in the case when members who disagree with the policy, with a resolution of the members' council. So, for example, the member council decide to reorganize the company, and I am asked the member. I say no, I did not agree with it. I vote against. But because when I cannot change the decision, so the only way I request the company to repurchase. Repurchase, that means they will return my money. Okay? So for example, I contribute 10 billion and other members. And the company decides to reorganize the company. I don't like it. I disagree with it. So I say, okay, please return my 1 billion. That is called repurchase. And now in the companies, they also have members who have more than 10%, and a group of members holding more than 10% of the capital. Now here, you can point out the term charter capital. The charter capitals means the capital that the company, all right, the charter capital is the capital that the company registered. So when the company formally registered with the authority, and the charter capital will be the capital listed in the company charter. That means the capital of the company recognized by law. So members or a group of members. So a group of members, for example, like in the company we have 10 members, A, B, C, they form a group. So the total contribution of A plus B plus C is more than 10%. Now, for example, the charter capital of the company is 100 billion, and the contribution of A plus B plus C together 15 billion. So that means they make off 15%. Or another case is like A itself have 20% of capital contribution. So that means A can be extra additional right. So here we can list some additional right of the group or the member who hold more than 10%. So they can request opening, they can request for organizing a new meetings. They can check the books and they can check the transactions. They can examine the book or the minutes decision of the member council. They can request the court to revoke relevant resolution and decision of the council. Now, for example, like in a company, we have 20 members. Imagine that the member council passed a decision for selling a part of the company property to another one. And ABC is a group who control more than 10% of the company charter capital. They disagree with this decision. So they have the right to make a request to the court and ask the court, please revoke this resolution or decision. That is the extra right that can be given by a member or a group of members holding 10% of the charter capital. Now, talking about the company structures and management. The company structures, according to the law on enterprises, can be divided into 3 units, 3 parts. The first is the members' council. That is, the member council will have the participation of all members. So all members make up the member council. Okay. The second one is the president of the member council. So the president of the member council will be elected by the members. So they serve as the president of the member council. Beside the president members, they have the directors or general directors. So director or general director is depending on the size and the particular structures of the company, whether they call just only one director or they have some directors and someone is going to be a general director. So the member council, all right, let's talk about the member council. The member council is the highest decision-making body. So this is the most important body of the limited liability company. And the member council is similar, right? It's in the same way. It's similar to the partners council in a partnership. In a partnership, the highest and the most important body of a partnership is the partners council. So in the limited liability companies, the biggest, the most important body is the member council, and the members council is the highest decision making. So this is the body to pass the decision. The member council make up all members of the company, including individual or the company organizations. And the members, so the organization, of course, they cannot be the participants of the member council. So if the organization is the members of the company, so the organization will appoint the representative. So the representative is the individual. Now the member council can help at any time by the request of the president or by the request of the members or a group of members representing more than 10% of the charter capital. So remember, not everyone has the right to request the council meeting. The council meeting can make the decision by means of vote, by means of request opinion in writing, or remote. For example, like they can create the poll, or they can use a yellow. For example, the council meeting can be held through yellow, and they can form a meeting through yellow meetings, or they can vote by sending the through yellow, for example. It's depending on the company charters. Now, the next important issue is that we have to look at the validities of a council meeting. So that means the council meeting can be held by the request of the president of the member council, or by the request of the members or group of members who have more than 10% of the charter capital. But the meetings will be valid, okay, only in the case they qualify a percentage. So for the first time, right, the first time the requirement is that the attending member must represent at least 65% of the charter capital. So for example, like the an LLC have the charter capital is 100 billion. So once again, I explained the charter capital means the capital that the company register with the authority, and this is amount to uh, mentioned or written in the company charter. So that's why they call the charter capital. So for example, like the company want to organize a meeting, they need to have, it doesn't matter how many percent to participate, how many participants, it doesn't matter. As long as, right, as long as the members represent 65% of the charter capital. So for example, if the attending members, it doesn't matter how many, but the capital represented by them is 60%. So that means the meeting is not valid. If they have the participation of the members and the total capital represented by them is 70 billion, so the meeting is acceptable. So sometimes the first meeting is unsuccessful, and then the second meeting will be held within a period of times. It's gonna be 50%, so the percentage is reduced. The third one is if the second time cannot be successful, and they have the third one, but the third time they don't count on the charter capital represented by the participant. So the numbers of attending is not necessary. And moving on to the next one is the mode of adoption of decisions. The adoption can be in the form of meetings, or they also adopted in writing, and the percentage which is minimum to pass a decision depending on the matters. For example, the matter which is important matter, they need 65% of the vote representing the capital contributions. For the service, for the very important matters, it needs 75%. So what matters are important and what matters are very important will depend on the company charters, and it is provided by Article 59.3. Okay, so the rights and duty of the member council is provided by Article 55.2. And moving on to the president. The president will be elected by the president must be members of the company. The president of the member council will be the company legal representative, and the term for the president of the member council is 5 years. They act the right or the duties provided by the law on enterprise. And the other one is we look at the managers, the directors of the general directors. So the president of the member council is the person who is in charge, who is the head of the member council. And the director or general director is the person who runs daily activities of the company. Right? So the question is very simple, so we don't say much about it. The company also have the inspection committee. The inspection committee will apply for the state-owned enterprise and subsidiaries of the enterprise. So they have maximum 5 members, which is re-electable. And we also have some questions regarding some contracts must be approved by the member council. So in order to avoid the abuse of power, or in order to avoid the complicated, so the contracts, some kind of contract must be approved by the member council. Like the members authorize between the company and the members, or the members and the authorized, or the members and the directors, or the members and the company, or the related person of this. Now, for example, like I am the members, and I have the contract with the director. So this contract must be approved by the member council. All right. Okay, so I suggest that we take around 10 minutes. All right. And then we will come back later. 10 minutes. Okay, let's resume. We still have around 45 minutes. Everyone still hear me okay? Clearly?
Okay, sir.
Yes.
Yeah, okay. Okay, good. Thank you very much. This is 12 o'clock now. I think you're tired. Okay, let's try to suffer from another 45 minutes. Now, let's talk about the one members limited liability company. It is another form, one of the two forms of limited liability company in our law. The one limited liability company is similar to a private enterprise, but they're not the same as a private enterprise. Totally different. It's totally different from the private enterprise. One members limited liability company is an enterprise that owned by organizations or individual. So one members, so the member can be either organization or individual. So unlike private enterprise, the members of this form of limited liability company can be organization also.
Excuse me, teacher.
Yes.
I cannot
Yep.
see the slides.
Oh really?
Yeah.
Sorry. I do it now. Okay, here. So I think it's okay now. Right. The limited liability company with one member is not the same as a private enterprise. The private enterprise, the members can only be individual. But limited liability company with two or more members, the member can be organization and it can be individual. Now we have to look at the characteristics. So one member's limited liability company, in principle, it is a limited liability. So it is a type of limited liability company. This form has legal entity status. So legal entity status make it different from private enterprise. Unlike multiple members limited liability company, this form of company has only one members. So the members is organization or the individual. But similarly to limited liability with two or more members, it have limited liability of the company and the members is also limited. So that means although the company has one members, so when the company has debt or any other kind of financial obligation needs to pay, the company has to be liable by the excess of the company. And it is similar to multiple members limited liability company, and it is the common characteristics of limited liability company. This form of company cannot issue shares also. Now the company owners, the rights of the company owner can be divided into whether the owner is organization or the company owner is individual. It's stipulated by Article 76. And the obligation is Article 77. Now we can bypass this and let's talk about the company structures and management. It depends on whether the company members is organization or the company member is individual. So depending on the members and the structure is different. According to the current law of enterprise, the company, the one member limited liability company company which the owner is organizations can select between the two different forms. The first form or the format or the model, that is the company owner will appoint one representative, and this representative of the company owner. So remember, in this case, the company owner is organization. So the organization will appoint one authorized representative, and he will act as the president of the company, and he can at the same time to be the directors or general directors of the company, or the president of the company can elect or can employ someone to be the directors or general director. So in this model, the president means the authorized representative of the company. So the president of the company, in fact, has to work under the direction and for the benefit of the company owner. That is the model number one. The second model, that is also selectable. That means the company owner, which is the organization, can choose the model, the second model. The second model is that the company owner will appoint from 3 to 7 members, and each of them have the term which is not exceed 5 years. And they will have the members council, and they have directors or general director. The member council in the model, second model, will mean all authorized representatives. Now, I would like you to look at the two models, and please tell me, okay? Please tell me what is the difference between model 1 and model 2. So we have model 2, 1, the company owner appoints one authorized representative. He is the president of the company, and he can also the director or general director. Model number 2 is that the company will have the council, which made up from all authorized representatives. It can be from 3 to 7, and also they have the directors or general directors. What is the difference? And the two models are selectable. So the company owner, which is the organization, can be free to choose which one that is suitable for them. All right? They can choose from model 1 or they can choose from model 2. So you look at model number 1, because the company owner will only appoint one authorized representative, then he will be the president. In model 1, the company will not have the member council because they only have one person. But in the model 2, the company have the member council. But the member council in this case is not the same as the member council in the LLC with 2 or more members. The difference, right? There is a difference. Different in terms of that the members of the member council are not the members of the company. This company has only one member, and 3 to 7 members to form a members council. They are all persons appointed by the owner. So my next question is, please tell me, okay? What is the benefit of creating a member council? Because if the company owner choose model 2, it will have to appoint from 3 to 7 members. It make it complicated. But if the company owner choose the model 1, they just need 1 member to be representative, and then there is no member council. So what is the benefit of having members council? I think the question is not so difficult, right? What is the benefit of having the member council here in a model 2?
Um, well, I think it will help with the decision-making process because one person, it's very hard work to decide
Right.
all of the aspects of the business.
Great. Yes, it will enhance the teamwork, so it can benefit from teamwork. 3 to 7 members, although they are authorized by the same company owner. When they when they participate in a decision making or discussions, they can attract the different view. They can make use the best of discussion and teamwork activities. Therefore, they can make a good decision. And the member council will be suitable for the company site if they have a big site. So the company can allocate the members to work at a number of functions in the company. So it depends on the company whether they want the model 1 or model 2. So the president of the company, they are appointed or dismissed by the company owner. They will be the company representative. They will be in charge of the conducting right and obligation of the company owner, and the president of the company will be responsible before the law and before the company for the rights and obligation. So actually, the real boss of this form of company is not the president. The real boss, the real owner of the company is the organization that is the owner of the company. So, for example, my company decide to establish a one-member limited liability company. So, my company is the owner of that LLC, and we have to decide whether we and follow model number 1 or model number 2. So, imagine that we follow model 2. So, I will select 3 to 7%. If I go for model number 1, so I just only appoint one person. He is not a real boss. He actually the person to act on behalf of myself. So the other directors are direct general directors. The main function of director or general director is to manage the business operation of the company, and they are responsible before the law and the member council for the activities, for the right and duties. And moving on to the second type of member company, like where the company member is the individual. The law doesn't say much, and is everything decided by the company owner, because the company owner is the owner, so he can directly become the president or the director or general directors. He can also employ someone to act as director or general director, and the way he can manage, the way he control, the way he organize the company will totally depend on the intent of the owner. So we don't have much things to say about it. Now, finally, we move to the fourth form of enterprise in our company law. Enterprises law is the shareholding company. So sometimes we can have another term that refer to this form of a company, which is like a stock company. And stock company, of course, can be used to in the same meaning as a shareholding company. A shareholding company, that means the company held by share. And the stock company is the stockholder. Is the stock company means the company held by stock. So the main issue is stock or share. But although stock or share may have different way to use, they are the same in terms of the basics. However, when we talk about shareholding company, we refer to a shareholding company in general. Stock company will refer to a kind of shareholding company which they provide, they offer share in the stock market. So when we use the term stock company, it may refer to the fact that the company listed in a stock market. So that's why I prefer to use the term shareholding. That means the company by share, but because not all companies are listed in the stock market. So if you have chance to study on stock market issue, so you will see that not every company go to stock market. And although you want to go to stock market, it generates you a lot of benefit, but not everyone can eligible to go to stock market. You know, the stock market is something like a market where it allows you to sell or buy your stock, but not everyone have that right because you have to have say qualified. You know, the company have to qualify some requirements. So in order to list it in the stock market, your company must qualify some requirement. So that's why I use the term shareholding is better. Okay. Now for the definition of the shareholding company, we base on the characteristics. The best description about the characteristics of the shareholding company is that the share capital is divided into equal portion. Now, what do I mean by say equal portion? So you look at like a pizza. In a pizza, the pizza can be divided into many slices, and one share is equal to the other share. Now, for example, like the company have 100,000. Okay, 100,000. Like a share capital is 100,000. And a share is valued at 10,000. So therefore, the company have 10 shares. So if the company have 100 shares, so the total capital will be 100,000 or millions. That means the share capital is a share is equal. So if you have 5 shares, you have 5 multiplied to the value of one share. Now, for example, like a share is 20,000 Vietnamese dong. And if you owe 10 shares, so you will have 200,000. If you owe 100 shares, you have 2 million. If you owe 1,000 shares, you have 20 million. If you have, say you have 100, if you have 1 million, so you can multiply to 10,000, for example, 20,000. So it depends on the value of the share. The share capital means the final after all share has been paid. And so, for example, the share capital will be counted based on the total value of 100,000 share that has been paid. And they can multiply to the value of each share, and we'll have the final amount of money will become the share capital. But for the shareholding company, when it first established, the shareholding company can only issue the share, which is the minimum is 10,000. Okay, it's 10,000 now. So after the company is established, and for the next issuance of the capital, the company can have the value of each share can be changed. So for example, at the beginning it's 10,000, but after 2 years of performance, the share is gonna be 20,000, or it can be double, or it can be lower and even than 10,000. Now, for example, in 2020, for example, my company established for the first time, so one share will be 10,000. But in 2021, my company unsuccessful, and the performance is not good, and now the value of one share is like 5,000. But in another way is if the company is operate well, and the value of share can be increased. If, for example, it can be 25, 30%, 30,000, or even 50,000. So you can make money when you invest your money in buying the share in the company. The second characteristic is the minimum members of the company must be 3. So when the company is established at the first time, the company must have at least 3 founding shareholders. And unlike limited, I say it again, unlike limited liability company, the members has no maximum limit. So the company can have 1 million of shareholder, or 20 million of shareholder, or 3 or 4 million or something. This depends on how the companies. Remember, the limited liability company, the minimum is 1, but the maximum is 50. The members of the company cannot exceed 50 members. The second one is now can be organization, and shareholder can be individual. So everyone can be everyone can be the shareholder. And when they say organization can be the shareholder, so that means part or limited liability company can be the. But the restriction here is a private enterprise. According to the law, a private enterprise cannot become the shareholder. Now everyone can explain why the law doesn't allow a private enterprise to become a shareholder. That is going to be the good one. Okay, why the law doesn't allow a private enterprise to become members of shareholding?
I think the reason is to reduce the risk, because that personal property is dedicated to the private company.
Yeah.
So there is a huge risk that that personal property will gone with the debt of the private company, and the shareholding company wouldn't have anything else. We wouldn't have any money left to pay for. So it's risky.
It's risky for a private enterprise because it's a one source of finance cannot be used for 2 reasons, 2 things. So the private enterprise is not eligible to become the shareholder. But the partnership or limited liability company can become the shareholder. And any kind of individual, as long as he or she qualify the capacity. So, for example, he or she must be over 18 years old, and he or she can be able to be aware of and control the behavior, so can be the shareholder. As long as he or she has money. So if you try to practice, so you can use some of your saving to buy stock, for example. This is a good one. The shareholding is a limited liability company. So it's similar to limited liability company. So remember, shareholding company, okay, let me say it again. Shareholding company is also a limited liability company. So limited liability company can be used as the term refer to the forms of enterprises, and they can be LLC and shareholding company. So that means when the shareholder become the members, they have to transfer the property, all right? They have to transfer the property to the company. How? Okay, the difference between the transfer of, the difference between the transfer of capital in a limited liability company and the transfer of capital, the contribution, the difference in terms of the contribution of capital between the limited liability company and the shareholding company is that in a limited liability company, the contribution can be in the form of contribution of capital. Simply contribute of capital. But in shareholding company, the only way for you to contribute the capital is that you have to buy the share. So the more share you buy, that means the more contribution that you contribute to the shareholding. For example, you have 1 billion, okay, and then you want to use 1 billion invest or contribute to the company, and then the only way is that you have to buy the share. So it depends on how much the share of the shareholding company is, and you can have the number of share corresponding to the price of each share. The next characteristics of the shareholding company is that the share is free to transfer. If you still remember, for the limited liability company, okay, for a limited liability, the transfer of capital contribution is limited. Do you still remember that if I am a member of the shareholding company and I want to transfer my share to someone else, it needs to follow 2 steps. The first step is that they have to ask to offer to my existing member first. If no one interested in, and then I can transfer to other members. But in the shareholding company, so the transfer of share is easy. So you can transfer to anyone you like, as long as they want to take the share. But remember, in the shareholding company, you are not allowed to withdraw the money. So when your money is gone for the contributions, so you cannot, right? You cannot get your money back, because in this case, your monies will not, the company basically will not return the money that you already paid to buy the shares to become the members. So in this way, you cannot get your money back. I mean, you cannot withdraw your money, but you can get your money back by transfer to someone else. Now, for example, I have 1 billion in the company, and I cannot ask the company to get me 1 billion back. but I can offer to sell my shares to someone else as long as they want to pay back to me 1 billion or maybe more, and then I can transfer to someone. So the transfer is very easy. But here they have some limitation. So here we have the limitation applied to the founding shareholder. So founding shareholder will be limited to the rights to transfer. Now you can look at here, right? The rules say ordinary shareholder, founding shareholder can transfer to another shareholder. But if he or she want to transfer to another person, he or she must get approval from the shareholder meeting. So I will talk about this shareholder meeting later. So that means for the founding shareholder, the transfer right, the rights to transfer is a limit. So you cannot transfer to anyone you like. If you are the founding shareholder, for the first 3 years from the date of the company establishment, you are not allowed to transfer to someone outside the founding members. If you want to transfer to someone outside the founding members, then you have to get the approval of the shareholding member. But once again, okay, my friend, can I ask you one a little bit difficult question? That is why? Why the law say founding members can only transfer the share to someone outside with the approval of the shareholder meeting? Why? This is a difficult question, but I would like to ask. Ordinary shareholder is okay, no limit, so you can transfer to anyone you like. But the founding members, for the first 3 years after the company established, you are not allowed to transfer to someone else outside the founding members. And if you want to transfer, you have to have approval of the shareholding members. Why?
Because it will affect the management responsibilities of the founding shareholders. Like the founding shareholders usually have a large percentage of shares. So if he or she transfer to a person outside the company, it means that a person outside will have the rights to decide to take up a very big decision in the company, and it may interrupt the teamwork and cooperation.
And it will affect, the direction of the company for the very first time. So, that only apply 3 years. 3 years, the first 3 years is the time for building up the company. 3 years, that is the time for the company to form the directions, whether the company gonna go. So it is time the founding shareholder will make the big decision. So it will not be affected by the decision of someone else outside. The sharing company have the legal entity status, and they can issue share to mobilize the capital. And I would like to explain a little bit about how to issue the share to mobilize. There are a number of ways to issue the share, okay? First, they can issue the share and the share will only make to existing members. So it will make internally. Another one is the share will be made to the public so everyone can buy. Another one is can be made to the stock market if the company is listed in the stock market. So there are a number of ways. It depends on the company whether they want to issue the share, whether it's also related to marketing purposes. Now, the establishment of a sharing company is a little bit complicated because it can be a number of stage. So I can divide it into the state. The first stage it is the formation state. In order to form a sharing company, it needs at least 3 founding shareholders. And the 3 founding shareholders will be the person who discussed and decide the important issues of the company. And one of the thing is that they have to draft the charter. So remember the charters or the company charters is the internal rules of the company. Okay, say it again. Company charter is the internal rules of the company. This document will specify important issues of the company. Everything will be decided by the company charter. So who will be the person to draft the charter? That means the founding. The founding shareholder will decide what issues are important, how to deal with important. So basically, in the charters of the company, it will specify something like type of share, rights and obligation of the company, right and obligation of the members, the capital, how to divide the dividend, the lines of business of the company, the structures of the company, the mode of management of the company or something. So they are important. So the second question is the registration state. The registration will be done by the company representative or authorized agents. Now, the next step is contributions. So the company, when it is established at the first time, it requires at least 20% of the share has been purchased and paid. And the rest of payment will be made by the subscriber. So you can imagine that in the formation state, they need at least 3 founding shareholders. And beside that, they have someone who interested will be a potential member. I call potential member because at this stage, the company has not been officially approved, so they have potential members. So the potential member will sign on the subscription. In the subscription, the potential member will commit to buy how many shares they want to buy, and they do not need to pay at the beginning. After fulfilling 20%, so they just only require minimum 20% of the capital share has been paid. The share has been paid, and then the company will be given the license or registration license. And after that, 90 working days after, the subscriber have to pay as they commit. Now, for example, when the company is about to establish at the registration stage, they imagine that the company want to issue 1 million share. Okay, imagine that when they at the very first stage at the beginning, the company intended to issue 1 million share. Okay, and when they submit to the authority, it will only need 20% of this. That means it will only need 200,000 of share has been paid. That is enough. And this 20% must be made by the founding shareholder. And after that, still have 800 800,000 share needs to be paid by the subscriber. The subscriber means someone who come and say, okay, I will buy set amount, number of share, I will buy number of share. And they are given they are given 90 days. So if the period of 90 days finish, so remember we have 800,000 share. Imagine that only 500,000 share has been paid by the subscriber instead of 800, but in fact they had only 500. So in this case, the capital, the charter capital of the company will be reduced, right? And they have to update with the authority. So when they issue the registration license, the authority recognized they have 1 billion, but after 90 days, not all share has been paid, so they have to reduce the final foundations, the final capital, charter capital, right? So then after that, we have the advantage and disadvantage of the company. So everything have two sides. The sharing company have the advantage because they have an entities, the company have limited liability, which have legal entity status. The way to mobilize the capital is very good because they can have many ways to mobilize the capital contribution. Is much easier and quicker than other. The stock transfer, that means the transfer of share will be easy among the shareholders. And perpetual life means the company will last longer. It will not be affected by the death of the members, or it will not affected by the withdrawal of the members. Yeah, so it can last longer. Beside the advantage, the sharing company also entails some disadvantage. That is the double taxation. So double taxation means the tax will be imposed on the company and the corporate income tax. But the shareholders also have to be personal income tax. So that means there has to be two types of tax. The tax for the company and the tax on the members. The company have a lot of complicated and strict obligations. They have to be controlled and supervised by the authority. A lot of obligation has to be fulfilled. The management is also not easy. It's difficult. And the the establishment will need a lot of cost, and the procedure is a little bit complicated. Right, I think that should be enough for our today, so we can, I say that we can stop a little bit earlier. Thank you for being with me. Right, and see you next week in person. So hopefully that you still recognize me when I enter the class. All right. Okay. So enjoy the rest of your day. Goodbye.
Goodbye, teacher.
Bye bye, Kelly.